For my presentation, I'll be discussing the history, application, and future of the insanity defense. Not guilty by reason of insanity is a controversial topic, one that my father has experience navigating. He had an extensive career as a forensic psychiatrist and is still practicing for the Department of Defense. I have interviewed him on the subject of the insanity plea, and using the background provided by this course, have gained a greater understanding of what not guilty by reason of insanity means and the psychology behind it. Insanity and not criminally responsible statutes and decisions have been controversial for much of our history, especially when these events involve highly publicized offenses such as assassinations and attempted assassinations. Often, following an offense with this type of publicity, there are reviews and modifications, such as the Colorado federal modifications following 1981 John Hinckley attempted assassination of President Reagan. Criminal law mandates that a crime involves two components: actus reus, the forbidden act, which must be voluntary and conscious, and mens rea, guilty intent. This is a concept that refers to the defendant's ability to develop a specific or guilty intent, i.e., purposefully or knowingly committing a criminal act. Since approximately the 4th century BC, there was a religious and moral sense in both the Greek and Jewish communities that an individual was not criminally responsible if they did not understand their act was illegal. Reparation procedures for a criminal act in England in the 11th century were related to an individual's sanity. 1724, in Rex v. Arnold, the wild beast standard was founded. Justice Tracy stated to the jury, for an individual to not be criminally responsible, they must be totally deprived of his understanding and memory, so as not to know what he's doing, no more than an infant, a brute, or a wild beast. Mr. Arnold was found guilty and ultimately sentenced to life in prison. The first recorded example of psychiatric testimony in a criminal trial was the Earl Ferrers trial of 1760. But the next notable case that resulted in a standard for the insanity plea was the Macnaghten trial of 1843, which Daniel Macnaghten, who was a Scottish woodturner, felt persecuted for years. He stalked the Prime Minister, Sir Robert Peel, believing that Peel was heading a conspiracy to kill him. He shot and killed Edward Drummond, the private secretary to Sir Peel, believing that Drummond was Peel. 4 psychiatrists examined Mr. Macnaghten, 2 for the defense and 2 for the prosecution. All were of the opinion that he was legally insane. In addition, 2 psychiatrists who only observed his demeanor in the courtroom testified that he met the criteria for insanity. The judge basically asked the jury if they had had enough, and the jury foreman indicated that they had seen enough as evidence, and then deliberated for less than 2 minutes before delivering the verdict of insanity. Subsequently, there was public outrage and concern by Queen Victoria. 15 judges of the Supreme Court were called together and asked to clarify and further define legal insanity. Of note, Queen Victoria on 6 occasions had pistols fired at her, and on another occasion was struck in the head with a brass-knobbed cane. In 1892, after she was shot with a pistol, she arranged to have the not guilty by reason of insanity verdict changed to guilty but insane in legislation. The disposition for the defendant remained the same, with detention at the asylum, typically Bethlehem Hospital, which was not a place that you wanted to be. The Macnaghten test stated that an individual is legally insane if at the time of committing the act, the party accused was laboring under such a defective reason from disease of the mind as to not know the nature and quality of the act he was doing, or if he did not know what he was doing was wrong with respect to the act that he is charged. Many states incorporated Macnaghten or variations of Macnaghten in their definition of legal insanity. In 1870 in New Hampshire, in 1954 in the District of Columbia, they both adopted a much more liberal definition of legal insanity called the product test. The 1954 Durham decision stated The accused is not criminally responsible if his unlawful act is the product of a mental disease or defect. This was much broader definition of legal insanity. The product test has been abandoned by most jurisdictions, including the District of Columbia, but is still used in New Hampshire. The Model Penal Code, also known as the American Law Institute test, was proposed in 1955. This was a two-pronged test in which there was elements of McNaughton and irresistible impulse concepts. Many states, including Colorado, had this as the legal definition of insanity prior to the John Hinckley assassination attempt on Reagan in 1981. Colorado and many states following this very publicized offense revised the legal definition of insanity, removing the irresistible impulse prong. Later, in 1995, the not guilty by reason of insanity definition was modified to include the previous definition of impaired mental condition, so essentially to include that second prong. This statute goes on to state that care should be taken not to confuse such mental disease or defect with mental depravity or passion growing out of hatred, revenge, or any other kind of motive and kindred evil conditions, because when the act is induced by any of these conditions, the person is accountable to the law. The statute states that diseased or defective in the mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conducts. The effects of voluntarily ingested psychoactive substances are also statutorily excluded from serving as a mental disease or defect. Nationally, insanity defenses are relatively rare and raised in approximately 1% of felony trials. They are successful about 25% of the time, and of those successful defenses, the vast majority are plea bargained. My dad's experience in Colorado is that well over 90% of the NGRI admissions are following a stipulation or agreement by the prosecution. A sanity and impaired mental condition evaluation is an examination that involves attempting to understand the defendant's mental state at the time of the alleged crime. Therefore, there are multiple sources of information that could be utilized when doing this evaluation. These sources include speaking with witnesses to the alleged crime, reviewing the defendant's past and current psychiatric records, police reports, crime scene photos and jail records, autopsy reports, a medical neurological evaluation, psychological testing, and most importantly, a clinical interview. The evaluator is extremely interested in understanding the defendant's knowledge of the criminality of the alleged crime. This would include a clear understanding of the defendant's behavior and thinking prior, during, and after the alleged crime. It is important for the evaluator to understand the distinctions between competency, sanity, and impaired mental condition. For example, competence and sanity are different concepts and not equivalent. Competence refers to an individual's trial ability. Not guilty by reason of insanity and not guilty by reason of impaired mental condition refer to an individual's culpability. The release criteria for individuals found not guilty by reason of insanity is that they have to no longer have an abnormal mental condition that is likely to cause them to be dangerous to themselves, others, or the community in the reasonably foreseeable future. Thus, treatment will focus on treating their mental illness, so they are not likely to be dangerous. Colorado has an indeterminate 1 day to life not guilty by reason of insanity commitment. Thus, defendants typically do not plead not guilty by reason of insanity to relatively minor offenses. 80+% of individuals found not guilty by reason of insanity in Colorado will have a psychotic disorder diagnosis, including schizophrenia, schizoaffective disorder, or a mood disorder with psychotic symptoms such as a manic phase of bipolar disorder. The general principle in treatment of this population is treating treatable risk factors associated with their dangerous behavior, such as substance abuse, psychotic symptoms, access to weapons, and conflicted family relationships. At my father's hospital, they have unrestricted use of psychiatric medications, including atypical antipsychotic medications like clozapine, risperidone, and various antidepressant medications, including selective serotonin reuptake inhibitors. Over the course of treatment, these individuals will progress to less secure areas with decreasing structure as their behavior and mental statuses are monitored. With ongoing clinical stability, they will further progress. Ultimately, these individuals will transition to the community, and with continued clinical stability, conditional release. The average length of stay of an individual that is placed on conditional release is about 8 to 9 years. At my father's hospital, they use two relatively formalized treatment programs. One involves the social learning program, and the other is a cognitive behavioral therapy called dialectical behavioral therapy. This is an empirically validated form of treatment that for individuals with a borderline personality disorder. Thank you so much for listening to my presentation. I've really enjoyed the opportunity to explore something of interest. So, thank you.